All right, now continuing this conversation, the problem appears to be concerning local government. However, administration in Nigeria is perceived to be inherent weaknesses in the constitution or high-wire politicking and deficit of honesty on the part of state governors. That's the question. Well, we're now being joined by lawyer First Babaisa to have a quick reaction to this. Good afternoon, a warm welcome to the program today.
Yeah, thank you for having me.
All right, well, let's get straight into it. Now, the Supreme Court ruling on local government autonomy was said to be a landmark ruling and elicited a lot of excitement from various parts of the polity. And then criticism came in that it was possibly unimplementable, if such a word exists. And this narrative or, the suggestion that some tweaks need to be made in National Assembly almost serves to confirm that as it is, it cannot be implemented. What's your take on this?
Well, I think there's actually two ways to look at it. First, I don't think the judgment, as it were, I've read every word of that judgment, need any intervention from National Assembly for it to be implemented. The judgment is clear-cut, it is precise and just straight to the point. The Attorney General of the Federation, the federal government, went to court asking for certain specific reliefs, and the judgment granted those reliefs. One is the local government funds allocation from the Federation should be going straight to the local governments. So these monies will not go to any local government without a democratically elected leader, executive, or legislator in place. Those are some of the specifics. So you don't need legislative intervention before this judgment can be implemented. In any case, the legislature don't implement laws. The legislature don't execute judgments. That is the prerogative of the executive arm of government. But having said that, I will agree with the school of thought that say the constitution, as it were, needs some tweaking to bring fully into view the perspective that landmark judgment have introduced. Because now the judgment in capsule has made it clear that the local government is no longer just a mere appendage of the state governments, that the local government is a top tier of our federation and it is supposed to be independent. But now that position raises some few questions. Number one, Section 162, especially subsection 5 and section 6, that created the joint federational account, maybe has to be removed. Two, who conducts elections into the local governments? Since now the judgment have said the local government is independent. So I think that is where some kind of legislation should come in, or a member of the constitution to say, okay, there must be a central body that conducts elections into local government. Lagos State cannot be conducting theirs, Cross River State theirs, Kano State doing theirs. Since now it is like an equal footing, it's a third tier. There's a federal government, there's a state government, and there is the local government. So there should be a central body that conducts. The state legislature should not have powers to make laws as it touches local government anymore. The second question is, after the election, the second question is, who now is responsible for, monitoring local government, making sure they perform? It's not independent. So the constitution should be amended to bring this fuller perspective of that land judgment clearly, so that practitioners of both politics and law and the citizen as a whole can know exactly where the local government is and how it functions. Lastly, some states have gone ahead to create their own local government councils. But if you read that judgment of the Supreme Court, it's clear that they cannot do that anymore, because the local government is a creation of the Constitution. It is now a top tier, just that's trinity equality with the federal and the state. So when that is made very clear bringing in a constitutional amendment, then I think that clarity will save us a lot of troubles.
Well said. Now, you touched on this lightly, but I'd like you to elaborate a bit further if you can. We know that critics have argued that constitutional amendment alone will not solve the issues plaguing local government administration. So my question is, what other reforms do you deem necessary that need to happen alongside constitutional changes for the real impact to be felt?
Well, that's easy. Somebody can easily say attitudinal changes. We should change our attitude. Politicians should change the way they approach issues. That's easy. That is something that somebody can easily say. But practically, as a lawyer, I think constitutional amendment will go a long way. Like, we should have, when the constitution is clear about the uniformity of who conducts election, the fact that states can no longer create local government councils is clear. The fact that a local government executive after election stays 4 years, this state cannot say it's 3 years, this state cannot say it's 2 years. I think that's going to help, because no matter how rugged, stubborn, anti-rule of law politicians are in this country, they obey the constitution to a large extent. There is no governor in this country that have stayed for more than 4 years. None. No matter how rugged or stubborn you are, no matter how wayward, to use that word advisedly, you are towards the rule of law, there is no time any president has stayed more than 4 years. So constitutional amendment will bring this clarity, and the politicians will not act against the law. But you see all these issues we're having now, where states are doing a lot of just taking different moves, amending laws. In my state, in Cross River State, my governor just signed the cross-sec law recently, just yesterday, bringing in some amendment because there's no uniformity. So Ekiti State will amend their own laws, Bayelsa State will do their own. But if constitutional uniformity, then we know that elections will hold at this time. Who is conducting elections? INEC or another central body. How long are they staying? 4 years. It gives clarity. And no politicians or lawyer or anybody will say, okay, in this state, the executives are going to stay for 5 years. But that's what's happening now. When it is clear, nobody is going to, a governor can just sit through an executive order and say that he has removed local government chairmen. But since there are no clarities inserted in the constitution, that is why there's a lot of room for our governors to do all this kind of what I call rascality.
In the spirit of that, to use your word, rascality, the financial autonomy judgment itself is yet to be implemented. Of course, there was a 3-month moratorium that was agreed upon, and that expires in October. So next month, we'll get to know whether it will take off or whether there will be, further negotiations and a further postponement. So again, are the issues really, ingrained in the Constitution? Whether we amend the Constitution or not, it seems that politicians have a way of behaving in their own interest. So what do you think is the ultimate solution here, especially with regards to financial autonomy? What are the options available to the various local governments across Nigeria who are going to need to start standing up for their rights come the expiry of that moratorium in October?
Well, I as a person, as a legal practitioner, waiting patiently too for the expiration of that moratorium. I am to see where we go from there. But at the risk of sounding boring, I keep reiterating that, why did the AGF even go to court in the first place in the Supreme Court? It's because of all this lack of clarity in our constitution as it pertains to the administration of local governments in this country. There's no clarity. One section is saying one thing, another section is saying another thing. One section is talking about independent, another section is creating joint account. There's no clarity. So the judgment is a very, very big leap towards giving us clarity about what the local government system really is, right? Yes, I agree with you. Politicians always act in their own interest. But as I said earlier, politicians manipulate the law when the law creates room for manipulation. When there's no clarity, politicians will come and create a lot of darkness around that lack of clarity, and do things for their own interests. So when there's a constitutional amendment that is clear, very clear, you don't need to give any local government or any state 3 months moratorium. Why? The main purpose of that moratorium, let's not forget, is because a large percentage of states don't even have a democratically elected local government officials or leaders in place. So the moratorium is like, okay, can you put this? Can you already put this? And that's why you see a lot of states trying to, bring out timetables to conduct elections, because everybody's in a haste to make sure they beat that moratorium. But moratorium or no moratorium, politicians acting in their interest or not, this judgment is good first step in the right direction. It should be followed. It should be followed with clear-cut constitutional amendments that will make the administration of local government, the conduct of elections, term of office clearly stipulated. Then politicians will have little or no room to wriggle and play all those their games.
All right. Now, how do you evaluate the role of the judiciary when it comes to the interpretation and enforcement of constitutional provisions related to LG autonomy? Would you say there's been a failure in this regard?
Not with the recent judgment we just had. That is like, it's commendable. There was a huge leap in the right direction. So that judgment has shown that the judiciary, when they want to, the judiciary can be bold, the judiciary can be pro-people. And I commend the judiciary for that step. The Supreme Court gave a very impressive ruling, because the issue of local government fund has become a hot pot, a potpourri of corruption in the system. And for them to put their foot down and say, come, this is what the law says, this is what the law proposed in this regard, I think they deserve commendation. It is now, the judiciary will not execute the law. It is now in the place of the executive to execute that law. It is also in the place of people like you and I, the citizens, to ask our leaders questions, to make demands that will bring the reality of that Supreme Court decision to bear in the lives of the common man on the street. Because the local government is the closest government to the people. They are the ones that produce or supposed to provide day-to-day services that will touch the people on the street. It has been bastardized over the years. So with this judgment now, let's begin to ask questions. Let local government begin to function. And I think it's going to be something that in the end we'll all very be happy about.
Now, some critics have said that the developments towards local government autonomy under this administration have been heavily political, or rather politicized, in the sense that this is aimed at taking away a little bit of accountability from federal government and putting pressure on the local government and their chairman. As you've said, they're closest to the grassroots. So taking attention away from the FG and focusing it on the subnational. What do you think are some of the unintended consequences that we might see of shifting our attention and, rather giving blame to the federal government for a lot of our problems and shifting those conversations to the local governments and, in essence, to the governors? Where do you see that conversation developing?
I think when the people are educated, when the people are sensitized, when the people are aware of how things work, that question will not even arise. Okay, but you have an educated masses that knows the clear-cut responsibilities of the federal government, the state government, and the local government. You know where to apportion blame when things are not being done right. Like, I know what the local, I will not go and ask the local government to do what the state is supposed to do or what the federal government is supposed to do. So the issue of shifting focus will not arise. It arises anyway when the people are not educated, when the people are not aware. But it shouldn't arise and wouldn't arise when we sensitize our people. You know, even when you talk about the road network, we know what is which one is a federal road, which one is a state road, and which one is a local government road. So when the people are aware, when you're asking questions, you say, You ask questions about who is supposed to do this. Is a local government. Local government, why have you not done this? The state, why have you not done the federal government? So I don't think that will exculpate the federal government from its responsibilities. We know what they should do. For instance, you cannot be asking the state government or the local government. You can ask my local government about building refineries. We know now that is not their responsibilities. But we also know that when we talk about primary health care, that's local government. So our focus should be that this money should get to the local government and let the local government do what the local government is supposed to do. That does not mean we'll stop asking the state government to do what they are supposed to do and the federal government likewise. So as I said, that question will not arise if the people are aware of the responsibilities and the duties that the governments at different strata owe us.
Well, this has been a very enlightening conversation, and we'd like to thank you for your time and analysis. Lawyer First Baba Issa, thank you so much for joining us here on Newsday.